For some reason, this story doesn't seem to be getting all that much coverage by mainstream media journalists. Viva Frei, Montreal litigator turned YouTuber, and this is Winnie the Westie getting ready for his afternoon nap in the car, and there is an update in the Project Veritas story. Now, this does not seem to be making mainstream news. For whatever the reason, we can hypothesize on that reason a little later, but a few weeks ago, Project Veritas had two of its former journalists raided by the FBI in the context of Ashley Biden's allegedly stolen diary. That's right, and this may come as a surprise to a great many people out there, but it seems that Joe Biden, the President of the United States of America, has another kid named Ashley Biden. Not many people were aware of Ashley Biden's existence, and apparently she had a diary which was allegedly stolen or potentially stolen and given to Project Veritas and shopped around at various other media outlets as well. And now, a year after this alleged leak of the allegedly stolen diary took place, the FBI is raiding former journalists who worked for Project Veritas. But it's not just that the FBI is raiding former journalists who used to work at Project Veritas. A week after the initial raids, they actually raided none other than James O'Keefe himself in yet another pre-dawn raid. A pre-dawn raid on James O'Keefe himself. And not only did the FBI orchestrate this pre-dawn raid on James O'Keefe, they might have possibly, potentially leaked this information to some reporters at the New York Times so that the New York Times could run a story while they knew James O'Keefe was detained and unable to respond to the story. And just the overview for anybody who hasn't seen my previous vlogs on the subject, about a year ago, some anonymous tipsters contacted Project Veritas saying they had what they thought to be an authentic version of Ashley Biden's diary, that this diary contained some very salacious details about her father then running for president of the United States. James O'Keefe was not sure that this was an authentic diary. They weren't sure as to the provenance of this diary, and they were negotiating with attorneys for the tipsters, ultimately decided not to run with the story, not to publish the diary. They attempted to give back the diary to the tipsters' lawyers, who refused to take possession of the diary. They then gave it back to the authorities. That was over a year ago. And about a year later, just like that, the FBI starts raiding not just the offices, but the homes of
actual American journalists.
Now, James O'Keefe, who might very well be in the best legal hands America has to offer at the time, filed for some emergency recourse to have the extraction of the data from his seized cell phones halted, and they succeeded in that request. Harmeet K. Dillon, blue checkmark. Harmeet Dillon is Project Veritas and James O'Keefe's attorney, and she single-handedly brings up the average IQ of Twitter blue checkmarks by at least 10 points. Breaking! Exclamation point. The federal court has just ordered the DOJ to stop extracting data from our client, journalist James O'Keefe's phone, and ordered a hearing. Counsel for Project Veritas asked the court to do this yesterday. And from the court order itself, United States District Court, Southern District of New York. In re search warrant dated November 5, 2021. Annalisa Torres, District Judge. The court has reviewed petitioner's motion for appointment of a special master dated November 10, 2021. Accordingly, 1. By November 12, 2021, the government shall confirm via email that it has paused its extraction and review of the contents of petitioner O'Keefe's phones. 2. By November 16, 2021, the government shall provide the court with its response to petitioner's motion. 3. By November 19, 2021, petitioner shall provide the court with their reply, if any. So ordered. Dated November 11, 2021. So that is the history and the procedural context of the situation that, for some reason, the journalists in mainstream media do not seem all that eager to report on, and because they want to ignore it, I'm going to put a little more emphasis on it, and I'm going to go through the response to the government's position, because when you hear the arguments the government is raising as to why they are justified in doing what they are doing,
I don't know how to finish that sentence.
In re search warrant dated November 5, 2021, case number 21 MC 00813 AT. Dear Judge Torres, on or about September 3, 2020, a tipster called news outlet Project Veritas and left a voicemail. In the voicemail, the tipster indicated that a new occupant moved into a place where Ashley Biden had previously been staying and found Ms. Biden's diary and other personal items. Quote, the diary is pretty crazy. I think it's worth taking a look at, end quote. And the rest of that introductory paragraph is the history that I just mentioned a moment ago. You can pause it and read it for yourself at your leisure, but moving on to the arguments raised by the government. Over 1 year later, the government seized journalists' cell phones and other electronic devices by the most invasive means possible in its investigation of an alleged, quote, theft, end quote. If a person not named Biden had misplaced her diary and overnight bag, would the FBI investigate at all, much less raid the home of one of America's most influential journalists? The case of the abandoned diary, or the case of the abandoned overnight bag, is an investigation better suited for the Hardy Boys than the DOJ and FBI. And that, ladies and gentlemen, is pretty much as funny as a lawyer's letter to a judge can ever get, get without the lawyer ending up in contempt of court and possibly jail. But as we'll see a little later in this response, the government is not only invoking the allegedly or potentially stolen diary because there are certain exceptions to stolen written materials, they are also invoking the alleged stolen handbag to justify their conduct. But before we get there, let's just look at what exactly James O'Keefe and Project Veritas are requesting of the court in this letter. James O'Keefe's and Project Veritas's request to this court is narrowly tailored. Appoint a special master to review the contents of the cell phones the government seized from journalist James O'Keefe. Appointing a special master will safeguard attorney-client privilege, the First Amendment privileged materials, including confidential donor information. This request is justified by the critical interest in preserving such protections and upholding a free press. Further, the government's overreach and the irregularities of its investigation demonstrate that no government taint team could be adequately walled off under the circumstances. A government investigation of journalists and a news outlet that researched but ultimately did not run a news story about the president's adult daughter's diary. Taint team might be the most appropriate name for a government entity I have ever heard. But above and beyond the government taint, what exactly is a special master? Legal Information Institute, open access to law since 1992. Special master, a quote, special master, end quote, is appointed by a court to carry out some sort of action on its behalf. More simply put, a special master is, in theory, an independent third party who carries out functions for the court at the request of the court because neither of the parties are sufficiently independent to do it for the court. And the most interesting thing in all of this, for reasons that should be sufficiently obvious, the Department of Justice does not want to appoint a special master. They want to continue acting basically without any form of independent verification. And what is their argument for why they were authorized to raid and seize items from James O'Keefe? He's not a real journalist.
What you just said is one of the most insanely idiotic things I have ever heard.
The government's, quote, not a journalist, end quote, argument emphasizes why a special master should be appointed. The government makes its hostility to Project Veritas and thus a free press patent. The government's response demonstrates its hostility to Project Veritas and thus a free press, writing, quote, Project Veritas is not engaged in journalism within any traditional or accepted definition of the word. Its, quote, reporting, end quote, consists almost entirely of publicizing non-consensual, surreptitious recordings made through unlawful, unethical, and or dishonest means, end quote. To borrow the words of another federal district court judge who granted directed verdict for Project Veritas in a case challenging Project Veritas's investigative journalism, quote, I keep running that 60 Minutes investigative journalist Mike Wallace analogy through my mind. If you made this argument about Mike Wallace, would everybody in the room laugh, end quote. Can you believe the audacity of the government to say that Project Veritas and James O'Keefe are not real journalists because they publish things that are non-consensual and they go about getting information through investigative means? Imagine if, to be real journalists, you could only publish that which the government gave you consent to publish. I would argue that at that point you're no longer a real journalist, you are just a useless mouthpiece for the government. The response letter then goes on to highlight the importance of investigative journalism in the American consciousness, and I don't think anybody with a reasonably open mind really needs to be reminded of the importance of investigative journalism, but it goes on to highlight what another very famous journalist had to say about the raids. Reacting to the government's execution of the search warrant at Mr. O'Keefe's home, Pulitzer Prize-winning journalist Glenn Greenwald wrote, the reason this is such a grave press freedom attack is twofold. First, as indicated, any attempt to anoint oneself the arbiter of who is and is not a, quote, real journalist, end quote, for purposes of First Amendment protections is inherently tyrannical. Which institutions are sufficiently trustworthy and competent to decree who is a real journalist meriting First Amendment protection and who falls outside as something else? But there is a much more significant problem with this framework. Namely, the question of who is and is not a real journalist is completely irrelevant to the First Amendment. None of the rights in the Constitution, including press freedom, was intended to apply only to a small, cloistered, credentialed, privileged group of citizens. The exact opposite was true. The only reason they are valuable as rights is because they enjoy universal application, protecting all citizens. What was protected by the First Amendment was not a small, privileged caste bearing the special label, quote, journalists, end quote, but rather the activity of a free press. Gosh darn it, Glenn Greenwald, I haven't used this meme in a while, but it is perfect. Another equally bad and disingenuous argument that the government raised to justify its conduct is that James O'Keefe and its journalists use an app called Telegram. It's a big, bad, scary app. Anyone using it has to be up to no good, therefore their conduct was justified. In keeping with its practice of obfuscation, the only specific, quote, fact, end quote, the government includes in its response is fake. The government redacted this sentence for the public version of its filing, but redaction is entirely unnecessary. What the government's sinister-sounding phrase refers to is the fact that Project Veritas journalists used the popular messaging app Telegram to communicate. This is an entirely ordinary means of communication. Telegram is readily available for download for free on Apple's App Store. At the time of this writing, Telegram is the 6th most downloaded app in the social networking category. There is nothing strange or sinister, and certainly nothing suggestive of probable cause in the use of a free, standard messaging app used by the likes of BBC, Bloomberg News, the New York Times, and the Washington Post. According to the response, another reason the government invoked to justify its conduct is that they were investigating not only the potential theft of the diary, but the potential theft of other materials belonging to Ashley Biden, but apparently they failed or neglected or refused to do any investigation that might reveal that this was a false pretext. As our investigation continues, we have learned that the government has deliberately avoided learning information that disproves its false theory that Project Veritas was somehow involved in a, quote, theft, end quote. The undersigned have interviewed the individuals who steered the sources who found the abandoned diary and other abandoned personal items to Project Veritas, including the tipster who left the voicemail for Project Veritas on or about September 3, 2020. Astonishingly, the government has not interviewed these individuals despite knowing their identities and listing them by name in the documents. From an investigative standpoint, the government's choice not to interview them is inexplicable. The government's position apparently is that their investigation is limited in scope to the allegedly stolen diary and allegedly stolen personal belongings of Ashley Biden, that they're not interested in anything else that might be found on James O'Keefe or the other reporters' cell phones, but that doesn't exactly quell the concerns of James O'Keefe or Project Veritas. A meaningful First Amendment injury occurred at the point FBI raid teams seized Mr. O'Keefe's digital notes containing news sources within the Biden administration, plans for upcoming news investigations, and donors to Project Veritas not aligned with the current administration. That damage is only amplified by allowing the government to search those materials without use of a special master, without access to or adversarial hearings about materials suggesting journalists acted outside of Barnicki. A truly exceptional claim. The government is free to run roughshod over its express protections. According to the response, the government's position is that its finding of probable cause was justified by the fact that Project Veritas was allegedly actively involved in the suspected theft, and they invoke a law called the Privacy Protection Act, but lo and behold, it seems that they might have not cited the full provision of the exception on which they are relying. What the government failed to disclose to the court is that the, quote, suspect exception, end quote, does not apply if the suspect offense involves the receipt, possession, communication, or withholding of materials to be used in disseminating a newspaper, book, broadcast, or similar form of public communication. The statutory language appears immediately after the language establishing the, quote, suspect exception, end quote. Provided, however, that a government officer or employee may not search for or seize such materials under the provisions of this paragraph if the offense to which the materials relate consists of the receipt, possession, communication, or withholding of such materials or the information contained therein. The investigation relates to newsworthy information and materials that Project Veritas obtained in connection with researching a news story that it considered publishing but ultimately chose not to. The search warrant executed at James O'Keefe's home was based on a theory for which the Privacy Protection Act expressly forbids the issue of such warrants: the receipt and possession of allegedly stolen property for use in news story. Government, you got some splaining to do, and to finish this vlog off with yet another reference to government taint. There is no government taint team sufficiently trustworthy to conduct the review of Mr. O'Keefe's cell phones. This is an investigation into the president's adult daughter's diary, or, as discussed above, possibly an investigation into her overnight bag. If the government's representations that it has complied with the Privacy Protection Act, regulations involving using search warrants to seize materials from members of the news media, and corresponding sections of the Justice Manual are to be believed, that means the government has obtained approvals from the highest levels of the Department of Justice, including the Attorney General himself. Well, I suspect we're going to find that out sooner than later, but the response letter saves one of the government's best arguments for last, and by best argument, I mean arguably most incoherent and laughably silly argument for last. The government argues that the case law submitted by Project Veritas is inapplicable because it only relates to solicitor-client privilege, not journalistic materials. Not content with denigrating Project Veritas's right to the protections granted by the First Amendment, the government suggests that First Amendment rights are somehow less worthy of protection than the interests served by the attorney-client privilege. Specifically, the government claims that the case law cited by Project Veritas for appointment of a special master are, quote, plainly inopposite, end quote, because those cases involve the seizure of attorney-client communications and work product, not mere journalistic materials. This argument is wrong both as a matter of policy and common sense. Whereas the common law recognizes protection for attorney-client communications and attorney work product, Congress enacted the PPA to protect news-gathering material from government seizure and compelled production. The suggestion that the appointment of a special master to review seized materials is warranted only when common law privilege issues are at stake is nonsensical. Moreover, here the government has seized materials protected by both the First Amendment and the attorney-client privilege work product doctrine. The government's attempt to distinguish the authorities cited by Project Veritas elevates form over substance. The response letter to the court then asks the court, among other things, to order the parties to submit certain candidates who could act as special master, that the court should appoint a special master from the list of candidates submitted by the parties, and that the court should basically set out the duties of the special master.
Duty. Diarrhea.
To be continued, and I will continue to shine a big, bright, shining light on this story because it doesn't seem that the mainstream media journalists are all that eager to cover it. But if you like my videos, you like my content, please be sure to like, share, subscribe, hit the notification bell, and drop a comment in the comment section below because it feeds the algorithm.
That's amazing.
If you want to support the channel, all of the support links are in the pinned comment. Robert Barnes and I do weekly streams every Sunday. We do weekly streams with a guest every Wednesday called The Sidebar. You can also find us and support us on Locals, where supporters get lots of exclusive content. You can find us at
VivaBarnesLaw.locals.com.
All of my content is also on Rumble, and since the merger between Locals and Rumble, you can now find a direct link to my Locals page from my Rumbles page, but more important than Rumbles page. But more important than any of that, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out.